Hi, my name is Amanda Rocha. I am an estate planning and probate attorney in California, and today I'm going to talk to you about the difference between an amendment to a trust and a restatement of a trust. Before I get into that, I'm going to give you my contact information. You can find me on my website at www.amandarocalaw.com. You can comment down below if this platform allows you to do that, or as always, you can find me on social media at Amanda Rocha Law. Now, the reason I am going to talk to you about this today is because I have a client currently who came to me with an existing estate plan and asked me to create an amendment for her. After reviewing her estate plan, there were a couple of reasons why we ended up doing a restatement instead of actually amending it. And I wanted to explain the difference to everyone because it's a small distinction, but it is important to know what you may need if you ever planned on doing it alone. And sometimes people will just give you what you ask for, especially if you're not going to an experienced estate planning attorney. So first of all, what's the difference? An amendment is what it sounds like. If you have a minor change that you need to make, you can amend your trust by creating a separate page or a few pages that amend, let's say, to give you a small example, let me think. A beneficiary in a certain circumstance only, or maybe you're amending a certain dollar amount for a percentage or something to a beneficiary. That would not require someone to create an entirely new trust for you, which is known as a restatement. So it's not really a new trust. So here's the difference between a restatement and a new trust. If you are essentially having the same trust, but you have enough changes to where multiple sections need to be changed, or if you're going to a new attorney to update an existing trust, or if you've written on your trust or somehow damaged it another way, then you would need a restatement, which is basically named as the same as your trust. So you wouldn't have to go through and change all of your funded items, such as you're recording a new deed for your house or life insurance policies if you've got a revocable trust or irrevocable trust, or anything like that, because it would still be called the same thing. It would just basically be a reprinted version of your trust with all of the new sections in it, and the old trust itself you could destroy. Now, creating an entirely new trust would mean it would be named something different. You would have to start from scratch, essentially, and you would need to update all of your accounts that you have funding your trust so that it is correct. If you have any questions about the difference between those things or why somebody might need one over the other further than I've explained now, please feel free to reach me. You can find me on my website, www.amandarocalaw.com. You can comment down below if this platform allows you to do so, or you can find me on social media at Amanda Rocha Law. Thank you.